Good evening, Dr. Zamri. Today, my group and I will be presenting on the topic of the evolution of strict liability, a comparative analysis and its role in modern law. My name is Vanya, and my group members are Yash, Yamira, and Diha. Strict liability is a legal doctrine which imposes liability without the need to prove fault or intention on the part of the defendant. Instead of focusing on the defendant's conduct, the emphasis is on the nature of the activity and the harm caused by it. This means that the defendant's mental state is irrelevant. The landmark case for this is Rylance and Fletcher, where liability arose when a dangerous thing escaped from the defendant's land and caused damage. Lord Keynes later added that the activity must involve in non-natural use of land. Although the rule originated from nuisance, it later developed into a distinct tort and it is recognized as part of Malaysian law. However, modern courts have begun re-examining its relevance. Now I'll be explaining the methodologies used by the courts to determine strict liability, which is using a qualitative approach. First is statutory strict liability, which arises directly from legislation. Courts examine statutory wording and parliamentary intent to decide whether fault is required. This is common in regulatory areas such as food safety and traffic offences, as seen in Gammon Hong Kong Limited and Attorney General of Hong Kong. Closely related is the public welfare or regulatory offence approach, which focuses on social protection rather than moral blameworthiness. In Harrow London Borough Council and Shaw, liability was imposed to ensure effective regulation. Another methodology is no-fault liability, where courts prioritize harm and causation over fault, illustrated by Rylance and Fletcher. Courts also apply enterprise or risk allocation, placing responsibility on those who create and benefit from risk. Judicial presumption, as seen in Sweet and Parsley, assesses whether mens rea should be implied. Finally, absolute liability applies in extreme public risk cases such as MC Mehta and Union of India. The first element requires the defendant to bring or accumulate something on their land for their own purposes. The rule does not apply if the thing was brought by someone else. An example is Miles and Forest Rock Granite Co. Limited, where explosives were deliberately accumulated on the defendant's land. When rocks escaped and caused injury, the court held the defendant liable under strict liability. The second element is that the accumulation must amount to a non-natural use of land. In Ricketts and Lothian, this was defined as a special use that brings increased danger to others and is not an ordinary use of land. Context is important, such as time and place, as explained in Reed and J. Lyons and Co. Limited. In Malaysia, Petronas Gas Berhad and DWZ Industries Johor Sendirian Berhad illustrates this, where industrial effluent was held to be a non-natural use. The third requirement is that the thing accumulated must be likely to cause damage if it escapes. Whether something is dangerous is a question of fact. In Ang Hock Hai and Tan Sam Lee, petrol stored for business purposes escaped, caused a fire, and resulted in deaths. The court held petrol to be a dangerous thing in this case. The final element is escape, and there must be damage caused by the escape. Escape means movement from the defendant's land to a place outside their control as defined in Reed and J. Lyons and Co. Limited. This can also be seen in Milik Perusahaan Sendirian Berhad and Kembang Masyur Sendirian Berhad, where earthworks caused a mudslide onto adjoining land and the defendant was held liable for it.
Hello everyone, Assalamualaikum. My name is Diha and I will be explaining the development of strict liability over the years. Jumping straight into it, the origins of strict liability dates back to Roman law, where the focus was on protecting injured parties rather than blaming fault. Its modern form developed in the 19th century, particularly through the case of Rylance against Fletcher, which imposed liability for harm caused by dangerous things escaping from land. Over time, courts have limited strict liability in common law and shifted towards force-based approaches. However, strict liability has continued to grow through legislation, especially in areas such as consumer protection, such as areas like consumer protection and environmental law. In Malaysia, laws such as Consumer Protection Act 1999 and the Environmental Quality Act 1974 imposes strict liability to protect consumers, the environment, and especially public safety. Overall, although its common law scope has narrowed, strict liability remains an important legal tool through statutory regulation in modern society and in today's world. That is all.
Alright, so I'll be explaining on the modern application of strict liability. First of all, we'll be taking a look at the artificial intelligence and also autonomous system. As we all know, autonomous system, artificial intelligence is being a part of our daily life. But have you wondered, what if there's an accident involving this system, then who will be held liable? Okay, let me give you an example. If a driver is driving a car and he gets into an accident, probably the driver will be held negligent according to the circumstances of the cases. But what if the car is an autonomous vehicle at level 4 to 5 automation, then who will be held liable? So in that scenario, the manufacturer will probably be held strictly liable. So if we take a look into the strictly liable aspect of a manufacturer, even though they are not negligent and they've exercised all reasonable care, they can still be held strictly liable if it falls under these three categories, which are manufacturing defects, design defects, and also failure to warn. So under the second restatement of tort, it has been mentioned that manufacturers are liable for defects that make a product unreasonably dangerous, and liability applies even if the manufacturer exercises all possible care and there's no need a contractual or purchaser relationship with the injured party. Okay, so if you're wondering how this claim can be brought up against the manufacturer, then we can take a look into these two different cases. The first one is Garcia against Character Technology, in which the plaintiff brought against the manufacturer two strict liability claim, which was the first one for defective design and the second one was failure to warn. Okay, in the second case involving an autonomous vehicle in the Hudson against Tesla Incorporation 2018, we can see in this case Hudson alleged Tesla was strictly liable for the design and manufacture of its autopilot system because it was defective and unreasonably dangerous. So when it falls under the three different categories, we can actually bring forward a strictly liable claim against the manufacturer. All right. All right, so the second aspect of modern application of strict liability will be e-commerce. So e-commerce is something that's growing rapidly and it's being used by everyone in this generation. So if there is a product that's defective that you have bought from e-commerce, then who is going to be liable for that? So in this context, strict liability will be applied towards the seller of the e-commerce. So we have to understand that strict liability poses a significant legal challenge for e-commerce businesses because sellers can be held accountable for defects in their products even if they were unaware of the issue or acted without negligence. So in certain jurisdictions, strict liability extends to every participant in the distribution chain, including online marketplaces that only connect buyers with third-party sellers. So this broad scope exposes platform to considerable risk despite not directly managing or inspecting the products themselves. So this can be seen in the cases of Bolger against Amazon and Solomis against Amazon, in which the cases have actually given a legal significance which is the expansion of strict liability in e-commerce, in which e-commerce, the sellers can be held liable for product defectives. So that's it from me on modern application of strict liability.
I'll be presenting about comparative analysis where every country has its own rule and standard when it comes to strict liability. For instance, India has rejected the rule of Reliance against Fletcher in the case of MC Mehta against Union of India. Chief Justice Bhagwati formulated doctrine of absolute liability because Reliance against Fletcher rule was very lenient and was not aligning with the Indian court rules. The ultimate definition of the doctrine of absolute liability is enterprise engaged in a hazardous activity is absolutely liable to compensate all those affected by an accident and there's no exception will be permitted. Moving on to Australia, where the country has abolished the Reliance against Fletcher rule because it was burdened by the exception of the unacceptable uncertainty of the aforementioned rule. The court, in the case of Burnie Port Authority against General Jones Private Limited, has replaced strict liability with the concept of non-delegible duty of care, ensuring that the dangerous activities, the reasonable care required functions with a similar precision to strict liability under negligence. Moving on to the United Kingdom, which follows the Reliance against Fletcher rule, although the modern court views strict liability as a deviation and to be replaced by negligence. In the decided case of Cambridge Water Company against Eastern Countries Leather Public Limited Company, the requirement of foreseeability of harm was introduced. Strict liability in UK survives through specific statutes such as the Consumer Protection Act 1987 rather than the common law. Moving on to Malaysia, the country stands somewhere between the middle of following the Reliance against Fletcher rule and expanding it all over the country. In cases such as Ng Kim Moy against Chong Him Sendirian Berhad, Malaysia actually followed the Reliance against Fletcher rule, where when someone brings in an object into a land which consequates to something, the liability will automatically relies on the person who brought it in. But in the Putra Heights explosion 2025, Malaysian court relied more upon the MC Mehta case of India. And plaintiff navigate the traditional hurdles of escape and non-natural use of to prove negligence, where Malaysia relies more on the traditional way of proving strict liability according to the Reliance against Fletcher rule. It also follows the UK and has its own codified statutes such as the Consumer Protection Act 1999 and the Environmental Quality Act 1974, which focuses on the polluter pays principle. To summarize, strict liability is one of the most important and debated doctrine as it has travelled from the industrial era of England to the modern world, and we can ensure that this is not a disappearing doctrine.